Will now call to order the House Committee on Labor and Commerce. We have more than enough seats, so I'm going to ask for everyone to have a seat. I'll now ask the clerk to open the rolls and take attendance. And I thank you all so much. We're going to begin the meeting at this time, and we have a very special presentation from the State Corporation Commission. They're going to discuss the biennial rate review case. You may have seen it, case number PUR-225-00058, State Corporation Commission. Thank you and welcome.
Thank you. Good morning, or good afternoon at this point, I apologize. Madam Chair, members of the committee, my name is Brian Pratt. I'm a Deputy Director at the State Corporation Commission, here today to provide an overview of Dominion Energy's 2025 biennial review proceeding and the specific determinations made by the Commission that address how data center customers will pay for utility costs. To start, you are currently being provided with a handout that is both front and back, which will highlight key recent and upcoming SCC initiatives addressing data center cost allocation, affordability, and reliability topics. I will touch on some of these in my overview today. Turning to the proceeding. In March of last year, Dominion filed its 2025 biennial review petition. The purpose of this proceeding was to set Dominion's base rates for years 2026 and 2027. In this proceeding, like all biennial review proceedings, the Commission, 1, evaluated Dominion's historic and projected cost to serve its customers, 2, set rates to recover Dominion's prudently incurred costs, and 3, determined how these costs will be recovered from different types of customers, such as residential, commercial, and industrial customers, including, in this instance, hyperscale data centers. I would note that these evaluations and determinations are routine and take place in each biennial review and many other SCC proceedings as well under the SCC's existing rate-making authority. With respect to setting utility rates for customers, the SCC has historically followed the principle of cost causation. That is, rates are designed for each type of customer to recover the cost that they cause. That same general principle was applied in this biennial review as it has historically been. I would also note that there was a lot of public participation in this particular case. Specifically, the Commission received hundreds of written public comments totaling more than 2,700 pages. The Commission also heard testimony from 27 public witnesses and 15 direct case participants over the course of a 9-day evidentiary hearing. Turning to the Commission's findings. In its final order, the Commission made several determinations to ensure that large load customers such as hyperscale data centers, appropriately pay for the cost incurred to serve them. First, the SCC will now set rates separately for large load customers to recover their unique cost in order to minimize cost shifting to other customers. This will be done by placing these large customers into a new separate rate class beginning January 1, 2027. This is called the GS5 rate class, which I know many of you have heard. The GS5 rate class will include all new or existing customers that meet or exceed certain capacity and energy usage thresholds. In addition to the GS5 rate class, the SCC adopted further provisions designed to minimize cost shifting risks associated with large load customers. I'll touch on certain key provisions of the Commission's ruling. First, the SCC established minimum charges. Specifically, large load customers will be obligated to pay at least 85% of the transmission and distribution cost incurred to serve them each month, regardless of their actual electricity consumption. These customers may also be obligated to pay minimum charges for generation. However, whether the customer pays minimum charges in the specific amount will vary depending on the customer's individual circumstances. I would note that existing customers who began service before January 1, 2016 will be exempt from these minimum charges. In reaching that determination, the Commission recognized in its order that established industrial customers may not present the same risks as new large customers. Second, the SCC established contract and collateral requirements. Large load customers will be obligated to take and pay for electric service for at least 14 years. Large load customers without sufficient credit may also be obligated to guarantee funds up front to cover up to 60% of their minimum charges over the life of their 14-year contract. These last obligations, the contract and collateral requirements, will apply to new large load customers who contract for service on or after January 1, 2027. So they will apply to new contracts going forward, but will not apply to existing contracts that are already in place today. Lastly, and importantly, I would note that this biennial review is not intended to be a one-and-done case on data center cost allocation and reliability topics. For instance, regarding cost allocation, the SCC ordered Dominion to submit alternative cost allocation proposals to better reflect the growth of large load customers. This directive is intended to further ensure that costs are appropriately allocated to those customers who cause them, including hyperscale data centers. Alternative generation cost allocation proposals were ordered to be submitted in Dominion's next biennial review proceeding, which will take place in 2027. Alternative transmission cost allocation proposals will be submitted in Dominion's next transmission rider proceeding, which will take place later this year. Regarding reliability, the SCC ordered Dominion to submit its process that it uses to interconnect large load customers to its system for the SCC's review and approval. Dominion submitted this filing with the SCC yesterday. Those are my prepared comments, my overview of the Commission's determinations. I'd be more than happy to do my best to answer any questions you may have.
Are there any questions from members of the committee? Please, I see that we have you, Delegate Singh.
Thank you, Madam Chair. I have two questions for the Speaker.
Yes.
The first question is, how do you define the megawatt usage by which someone is considered a hyperscale data center? If there's an entity is it 70 megawatts, 100 megawatts? What's the number you use?
Madam Chair,
Yes.
Delegate Singh. The Commission based its GS5 rate class on the demand and electricity usage characteristics of the customer. So it's not looking specifically at hyperscale data centers in isolation, although it will cover most of them. Specifically, it is targeted toward customers that have a demand of 25 megawatts, and what we refer to as a load factor, which looks at how they consume electricity over the year, of 75% or greater. Those are the customers that will be in the GS5 rate class.
Thank you, Madam Chair. Second question.
Yes, you may ask.
It says that it must pay at least 85% of their transmission and distribution costs. So does that include transmission lines above ground, underground? Does it include substations? What's included in that?
That includes, I would say, a little bit broader. It includes their broader distribution and transmission cost of service. And this just gets into a little about how rates are designed. The company has cost for distribution. The company has cost for transmission. Those are typically recovered through the billing rates of the customer based on their consumption, right, in a single set of rates. These minimum charges sort of put a floor on those rates. So, for example, let's say you have a customer that is contracted for 100 megawatts of demand and would require 100 megawatts of transmission and distribution infrastructure to serve, but maybe their electricity consumption that month is commensurate with 50 megawatts. This bill would ensure that they pay 85 megawatts regardless of their actual metered consumption that month.
Thank you so much. Delegate Cohen.
Thank you, Madam Chair. Question, I was going to say
Yes.
for the patron. It's been a long day already. Thank you so much for this. We certainly appreciate it. I think there's probably not a one of us on here who is not hearing from our constituents that, you know, that energy cost is breaking the bank. I will say our energy cost at our house, even with now 2 kids gone, was through the roof, higher than it's ever been for us. And I think, understandably, that our constituents really wanted there to be a different provision for large users, large consumers of energy. So I really appreciate you all looking into this. I think the only question that we'll get at home is the contract obligation. What was the sort of decision-making rubric for saying that anything before January 1st of 2027, so even next January, why not have the data centers have a minimum contract obligation?
I think what I could say is that was a commission decision based on the evidentiary record of the case and its order. The effective date of the provisions as approved were designed to be effective January 1, 2027. I'm not sure I could legally interpret the commission's finding beyond that.
Delegate Maldonado.
Thank you, Madam Chair. Thank you very much for your presentation today. I've had some conversations with you all around this, but wanted to, for the committee and just for clarifying around the 85% payment of transmission and distribution costs regardless of electricity usage. If we think about the sort of spectrum of transmission costs, whether it's for a project, it's something over here, can you explain that this 85% applies to all transmission costs, regardless of project, regardless of where it's in the pipeline, or is it only applying to a specific part of transmission costs?
I will try to answer that question as best I can. It's a little complex. Madam Chair, Delegate Maldonado, this would recover the costs of the transmission costs that are assigned to that class. And the company has transmission costs that are assigned to it from PJM through FERC process. So it's recovering 85% of those costs. There are separate allocation processes that go through PJM markets. So when a transmission project is approved, those costs are typically spread to the entirety of Dominion zones, so other utilities, et cetera, through FERC processes first. A certain portion of that is then assigned down to Dominion, and what this is doing is recovering 85% of those costs that are assigned to those GS5 customers. So it includes the projects that are assigned to Dominion's customers for recovery. I hope that answers your question. It's a little bit of a complex topic.
Madam Chair?
Yes, you have another question.
Thank you. A follow-up, just to clarify. So I guess what I'm trying to make sure I'm understanding is that there are scenarios where transmission costs would not be subject to this 85%, but there are the costs that are assigned to, as you said, would be covered.
I think I could say that the cost assigned to the customer, the cost assigned to Dominion, that are then in turn assigned to Dominion's customers through the SEC's regulated proceedings, these charges are designed to, for this customer to recover 85% of those costs.
Thank you, Madam Chair.
Thank you. You're welcome. And Delegate Shin.
Thank you, Madam Chair. My question might be a follow-up to what Delegate Maldonado was asking, because it sounds like what I'm hearing is that there is an ability now to allocate at least 85% of transmission and distribution costs, for example, to Dominion, like they're one customer that requires set amount of energy, like that 85% of it can be allocated to them. I'm wondering what happens to that delta and the 15% and why it's not being able to fully be recovered upon said customer, Madam Chair.
Yeah, I'll do my best to answer that one. Madam Chair, Delegate Shin, so the 85% is a minimum. It's not an absolute. So this would cover an instance where, let me back up for a little bit. So typically a customer is billed based on their actual metered usage, just as everyone else, the amount of electricity that goes through their meter every month. So this would capture a scenario where that electricity is dropped. Maybe the customer maybe they've contracted for example, 100 megawatts of load. Maybe they've curtailed, maybe they're using less that month. It puts a floor on that to ensure that in that month they're paying at least 85% of what they contracted for. If they are using in full what they contracted for, they would pay their full cost of service. So it's a safeguard intended to put a floor, but if they're using what they contracted for, they would pay their full cost of service.
Madam Chair.
Yes, Delegate
Just
Shin.
a follow-up question on that.
Yes.
Then if they're not using the full amount that they were contracted for, then inevitably that delta of potentially up to 15% is being shifted to other ratepayers in that service territory?
That could be possible.
Thank you. And Madam Chair, if I could ask one other question that's not necessarily
Yes,
related to
Delegate Shin.
the 15 or 85% here, but in this rate proceeding, I also understood that residential ratepayers' bills are going to increase $11.24 a month this year and an additional $2.36 a month next year. And then the commission also approved an ROE increase from 9.7 to 9.8%. And I wondered if, while we have the SEC here, if you could speak to the increase in that ROE percentage point.
I would not be the best person from commission staff to answer questions on return on equity. We do have Ms. Pate here, who would probably be more than qualified to help answer that question.
Thank you so much for coming and welcome.
Thank you. My first time up this year, Madam Chair, Delegate Shin. The 9.8 was based on all the evidence in the record. We have the biennial review. We had a range of potential ROEs supported by expert witnesses, anywhere from 6.2%, et cetera, to up to, I think it was like 10.25. So in there, they looked at all the evidence on the record and came up with the 9.8 as being the market price of equity. The commission did, excuse me, I forgot to say that part out loud. Mm-hmm. Does that help? So there was a range that they had to choose from, the commission, that is.
Thank you, Madam Chair. I think then the range was based on what you said. You mentioned the market, so looking at other states or other utility providers and their ROEs, or what was that based on?
It was based on the recommendations by the ROE witnesses in the case. We had a range from about a little over 6% to a little over 10%. And there were a variety of recommendations among the expert witnesses in the case on what should be the market price of equity, which last time it was 9.7. And based on market conditions, the commission determined that it needed to go up just a little bit.
Thank you, Madam Chair. Thank you, Ms. Payne.
Thank you so much, and thank you also for coming. I have a question from Delegate Clark.
Thank you, Madam Chair. Yes, two questions. The first question is pertaining to the 14-year contract. How does the 14-year obligation protect ratepayers if data centers demand or if the technology changes significantly within those 14 years?
Madam Chair, Delegate Clark, as I understand your question, I think what you're essentially asking is what happens if their circumstances change, and as a result of that, maybe they're no longer using what they contracted for within the 14-year term. Is that? There are safeguards in place in addition to simply the contract term. For example, if there is a drop in their contract demand, they are still subject to those minimum charges that I mentioned, right? So the 85% of transmission and distribution cost. If the customer were to, let's say, terminate their contract entirely prematurely, there would be an exit fee imposed on the customer intended to recover the cost of the contract.
Thank you. And I had one follow-up question, Madam Chair. Has the SEC denied or delayed any data centers due to reliability concerns?
I'm not aware that the SEC has delayed or denied data centers. Typically, the interconnection process is done by the utility, and specifically interconnecting into their transmission system, follows FERC processes. I'm not aware of an instance where the SEC has directed a delay or termination of a data center specifically.
Thank you so much. I see no more questions from any member of the committee. Then I'm going to thank you and all of your colleagues from the SEC for offering up yourself before this body to answer these questions. We appreciate your coming.
Thank you. Have a good afternoon.
Thank you. And so we'll begin with our subcommittee reports. We're going to start with Subcommittee 2. Chair Lopez.
Thank you, Madam Chair. We had several bills that were reported out, and I'll get started. HB 260 from Delegate Simons regarding prevailing wage rate for underground infrastructure. Under the bill, each public service company shall ensure that its bid specifications or other contracts applicable to underground infrastructure work require payment at the prevailing wage rate. The bill requires contractors and subcontractors to post the prevailing wage rate in a prominent and accessible place at the work site. The bill also requires each contractor or subcontractor subject to the provisions of the bill to comply with certain record-keeping requirements. The provisions of the bill apply to contracts entered into on or after July 1st of 2027. Madam Chair, the subcommittee recommends reporting with amendments and referring to appropriations. We did so by a vote of 5-2. And I so move.
Okay, it's been properly moved and seconded. We report this bill with amendments and refer to appropriations. Any questions from any member of the committee? Seeing none, the clerk shall open the roll so we can vote. And the clerk shall close the roll. The measure passes 15-7. We will report the bill with amendments and refer to appropriations. Next bill.
Thank you, Madam Chair. HB 338 from myself regarding building service employees in the transition period. It permits any locality to provide by ordinance or resolution for certain requirements concerning successor building service employers defined in the bill. For example, each local ordinance or resolution may require that successor service employers retain incumbent service employees during a transition period of 90 days. Under the bill, building service employees are those who perform work in connection with the care or maintenance of a property, certain transportation services, and food preparation services. The bill provides that a building service employer who violates the provisions of a local ordinance or a resolution enacted pursuant to the bill may be subject to a civil action and monetary damages. Madam Chair, the subcommittee recommended reporting with a substitute by a vote of 5-2, and I so move.
It's been properly moved and seconded that we report this bill with this substitute.
Madam Chair.
Delegate Weber.
Yes, Madam Chair. Question for the patron.
You may
If I may.
ask. You may ask.
Thank you, Madam Chair. I would ask the patron, so can you give an example of how this would work?
Yes, Madam Chair, I would respond to the delegate that if, say, a locality, say Alexandria, wanted to create some kind of displaced workers policy similar to what's been passed in other states and localities all across the country. What they would do is they would say, if a building is being managed by one company, Company X, and then they decide to sell their management or have another company like have the control of that company, so Company Y, as opposed to simply firing all of the custodial workers and all of the janitors and folks who maybe have worked in that building for 10, 15, 20 years through no fault of their own. They would simply provide these folks with, based on the, if permissible, the locality chooses to do this, a series of options, maybe requiring that the entity award the service contract, awarded the service contract, or the incumbent employer to notify workers that their employer may change, or requiring that the awards the service contract, whoever gets the service contract, the incumbent employer to provide the new employer with the names and contact information of the folks who are working at the building currently, and maybe give them preferential treatment as to be rehired. And also, maybe providing a 90-day transition period, which is common in some of these programs around the country, so that they know at least what's going to happen and they might lose their job. The issue here, as I raised during committee, was that unfortunately, although federal protections apply for a lot of these kinds of programs, these protections don't apply for workers in this specific situation. And that's why you have these displaced worker regulations coming up around the country. And so I think it's a basic fairness thing for individuals who might have been, through no fault of their own, caught up in the change of the ownership of a building and are all of a sudden out of work.
Thank you, Madam Chair.
You're welcome. Okay, it's been properly moved and seconded. Any other questions? Then the clerk shall open the roll so we can cast our votes. And the clerk shall close the roll. The measure passes 15-7. Chair Lopez.
Thank you, Madam Chair. The next bill is HB 340 from Delegate Martinez regarding migrant labor camp permits and expiration. That removes the annual December 31st expiration date for all issued migrant labor camp permits and provides that such permits expire 12 months from the date of issuance. Madam Chair, the subcommittee recommended reporting by a vote of 7-0, and I so move.
Okay, it's been properly moved and seconded. All in favor? Any opposed? Never mind.
Go to the bill.
I'm sorry.
Yeah.
Any questions from any member of the committee? Seeing none, I'll ask the clerk to open the roll so we can cast our votes. And the clerk shall close the roll. The measure passes 22-0.
Thank you, Madam Chair. The next bill is HB 547 from Delegate Helmer regarding private companies providing public transportation services and employee protections. It specifies that the governing body or transportation district commission of any county or city that contracts with a private company to provide transportation services shall require such company to, 1, provide each of its employees compensation or benefits as specified in the bill, 2, provide transportation services through its own employees, and 3, ensure that all employees of the public transportation system employed by a predecessor private company be offered employment with any successor company without loss of compensation or benefits. Madam Chair, the subcommittee recommended reporting by a vote of 5-2, and I so move.
Been properly moved and seconded. Any questions, any comments from any member of the committee? It looks like Delegate Weber.
Yes, Madam Chair. Question. So, as I understand it, the locality that hires a private entity to do public transportation, that this bill requires that private entity basically pay what the locality would pay their own people to be able to administer the program?
Madam Chair,
Yes.
may I address the
Yes,
sorry,
you may.
question? Madam Chair, it just says that in the case where there's a transfer to a private contractor between private contractors, employed by the locality, that the wage will be equivalent.
Further question, Madam Chair?
Yes, Delegate Weber.
Could this increase the cost of that transportation program for the locality?
Delegate Helmer.
Madam Chair, I would answer the delegate that we have seen in many localities that these transfers result in shutdowns, long periods of delay, a lack of quality that cost the individuals in those localities a tremendous amount of lost wages when they're unable to get to work because of shutdowns. Rather than increasing costs, this is far more likely to decrease the cost to consumers who no longer have to miss their jobs or miss the ability to go to work on time because of labor disruptions as a result of undercutting wages for critical workers.
Further question, Madam Chair?
Yes, Delegate Weber.
So essentially, the locality is telling a private company how much to pay their wages, and we're telling them that it needs to go up to pay what the locality would normally pay. And if that's going to increase cost, then the locality either has two choices: to either do it themselves or pay the higher cost. And if they pay the higher cost, would they not then have to raise taxes in order to cover that?
Delegate Helmer.
Madam Chair,
wish.
I would answer the delegate that in these instances, as recognized here, these are already collective bargained agreements in which the costs are locked in for the localities. There are many ways in which private contractors compete on costs. It just says they're not going to do so on the back of middle-class workers.
All right, thank you so much.
Thank you, Madam Chair.
Delegate Helmer. Any other questions? And we'll ask the clerk to open the roll so we can cast our votes. And the clerk shall close the roll. The measure passes 15-7.
Thank you, Madam Chair. The next bill is HB 627 from Delegate Herring regarding covenants not to compete for healthcare professionals and civil penalty. Madam Chair, the bill adds healthcare professionals as a category of employee with or upon whom no employer shall enter into, enforce, or threaten to enforce a covenant not to compete. The bill provides that any employer that violates the prohibition against covenants not to compete with a healthcare professional is subject to a civil penalty in current law of $10,000 for each violation. Madam Chair, the subcommittee recommended reporting with amendments by a vote of 5-2, and I so move.
Been properly moved in second that we report this bill with the amendments. Any questions from any member of the committee? Then I'll ask the clerk to open the roll so we can cast our votes.
Fix it again.
And the clerk shall close the roll. This measure passes 20-2. We pass with amendments. Chair Lopez.
Thank you, Madam Chair. The next bill is HB 670 from Delegate Maldonado regarding labor and employment provisions, application of law, protection of employees, definition of employer. Madam Chair, this bill provides that the exemption for the Commonwealth, any of the agencies, institutions, or political subdivisions, or any public body under Title 40.1 does not apply when expressly provided otherwise. The bill provides that for the purpose of various requirements related to the protections of employees, the definition of employer includes the Commonwealth and its agencies, institutions, and political subdivisions, and any public body. Madam Chair, the subcommittee recommended reporting with amendments and referring to appropriations by a vote of 5-2, and I so move.
Okay, it's been properly moved and seconded that we report this bill with its amendments and refer to appropriations. Any questions from any member of the committee? Then I'll ask that the clerk will open the roll so we can cast our votes. And the clerk shall close the roll. The measure passes 15-7 to report this bill with its amendments and refer to appropriations.
Thank you, Madam Chair. The next bill, HB 715 from Delegate Hope, committee recommended incorporating this bill into HB 1263, which was passed by for the day and will be heard on Thursday. So I so move.
Okay. Okay, it's been properly moved and second that we incorporate this bill with House Bill 1263. This is a voice vote.
Yes, ma'am.
All in favor, say aye.
Aye.
Any opposed? The measure passes.
All right,
We
thank
will
you.
report the bill and incorporate it with 1263.
Thank you, ma'am. HB 865 from Delegate Cousins is regarding workers' compensation and presumption of compensability for certain cancers. Madam Chair, this bill expands the workers' compensation presumption of compensability for certain cancers causing the death or disability of certain employees who have completed 5 years of service in their position to include lung cancer and non-Hodgkin's lymphoma. Madam Chair, the subcommittee recommended reporting with amendments and referring to appropriations by a vote of 7-0, and I so move.
Okay, it's been properly moved and second that we report this bill with amendments and refer to appropriations. Any questions, any comments from any member of the committee? Then I'll ask that the clerk open the roll so we can vote. The clerk. We're going a little fast here.
No, systems is.
Oh, the system is slow. Now we're ready. Here we go. And the clerk shall close the roll. The measure passes 22-0. We will report this bill with amendments and refer to appropriations.
Thank you, Madam Chair. HB 923 is another bill from me regarding protection of employees regarding stay or pay contracts that are prohibited and civil penalty. Madam Chair, this bill prohibits an employer from entering into, enforcing, or threatening to enforce a stay or pay contract as defined in the bill with any employees with certain exceptions described. An employer that violates the bill's provisions is subject to a civil penalty of $10,000. The bill allows an employee to bring a civil action against an employer or other person that attempts to enforce a stay or pay contract and to seek appropriate relief, including enjoining the conduct of any person or employer or ordering payment of liquidated damages and awarding loss compensation damages and reasonable attorney's fees and costs. The bill provides that if the court finds a violation of the bill's provisions, the plaintiff is entitled to recover reasonable costs, including reasonable fees for expert witnesses and attorney fees. Madam Chair, the subcommittee recommended reporting with amendments by a vote of 6-1, and I so move.
Okay, it's been properly moved and seconded that we report this bill with amendments. Any questions from any member of this committee? Then I'll ask the clerk to open the roll so we can vote. And the clerk shall close the roll. This measure passes 16-6. We will report the bill with amendments.
Thank you, Madam Chair. The next bill, HB 949 from myself regarding covenants not to compete. The subcommittee recommended continuing to 2027, and I so move.
Okay, properly moved and seconded that we continue this House Bill 949. This is a voice vote. All in favor signify by saying aye.
Aye.
Any opposed? The measure passes. We will continue this bill to 2027.
Thank you, Madam Chair. The final two bills, HB 1207 from Delegate Sewell regarding paid family medical leave insurance program, notice requirements and civil action. Madam Chair, this bill requires the Virginia Employment Commission to establish and administer a paid family medical leave insurance program with benefits beginning January 1st, 2029. Under the program, benefits are paid to covered individuals as defined in the bill for family medical leave. Funding for the program is provided through premiums assessed to employers and employees beginning July 1st, 2028. The bill provides that the amount of a benefit is 80% of an employee's average weekly wage, not to exceed 100% of the statewide average weekly wage, which amount is required to be adjusted annually to reflect changes in the statewide average weekly wage. Madam Chair, the bill caps the duration of a paid leave at 12 weeks in any application year and provides self-employed individuals with the option of participating in the program. Madam Chair, the subcommittee recommended reporting with a substitute and referring to appropriations by a vote of 5-2, and I so move.
Properly moved and seconded that we report this bill with the substitute and refer to appropriations. Any questions from any member of this committee?
Madam Chair.
Delegate Williams.
Madam Chair, I was looking for the fiscal report on this one.
Just a moment. It does note that it's being referred to appropriations.
All right, thank you, Madam Chair.
Is that satisfactory for you? That's good enough? Okay, yes. Any other questions from anyone from the committee? Once again, the motion is to report this substitute with the substitute and refer to appropriations. Are we now ready to cast our votes? We'll ask the clerk to open the roll. And the clerk shall close the roll. This measure passes 15-7. We will report this bill with the substitute and refer to appropriations.
Thank you, Madam Chair. The final bill
Chair
from
Sullivan.
Subcommittee 2, Labor and Workforce, is HB 13 from Delegate Carlson regarding workers' compensation, exacerbation of certain disorders incurred by law enforcement officers and firefighters. Provides that for the purpose of workers' compensation for post-traumatic stress disorder, anxiety disorder, or depressive disorder incurred by a law enforcement officer or firefighter, the exacerbation of any such pre-existing disorder incurred by a law enforcement officer or firefighter is also compensable. The bill also amends requirements related to such compensability, which include undergoing a qualifying event. Madam Chair, the subcommittee recommends reporting with amendments by a vote of 7-0, and I so move.
Okay, it's been properly moved and second that we report this bill with amendments. Do we have any member of this committee with any questions? Seeing none, I'll ask that the clerk open the roll so we can vote. And the clerk shall close the roll. This measure passes 22-0. We will report this bill with amendments.
Thank you, Madam Chair. That's the final bill for this week for Subcommittee 2.
All right. Thank you so much. Thank you. That's a lot of work you did. And I want to congratulate you and your subcommittee. Job well done.
Thank you.
Okay. Subcommittee report, Sub 3. Chair Sullivan.
Thank you, Madam Chair. Sub 3 met on last Thursday, January 29, and dealt with a number of bills. The first was HB 369 from Delegate Reed. There was a substitute which added zero carbon electricity to the Accelerated Renewable Energy Buyers Program and changed the name to Accelerated Clean Energy Buyers. The subcommittee recommended reporting that substitute by a vote of 9-0, and I so move.
Okay, properly moved and seconded that we report this bill with the substitute. Any member? Yes, we have a question from a member of the committee, Delegate Williams.
Yes, Madam Chair. Is this the bill Delegate Reed was working on that we kind of passed in policy but not necessarily words? Is this that bill? Or is that another one?
Madam Chair, I believe the answer to that is no.
Okay.
Any other questions from any member of the committee?
Madam Chair,
Delegate Weber?
sorry.
No,
Question.
don't apologize. We are open for questions. This is the time.
So, correct me if I'm wrong, Delegate Sullivan. So essentially, you're amending the renewable portfolio standard for a zero carbon electricity standard that allows for fusion and nuclear, at least according to the summary.
Madam Chair, in answer to the
Yes.
delegate's question, the substitute took out those portions of the bill and simply, as I described, changed the add zero carbon electricity to the Accelerated Renewable Energy Buyers Program and changed the name of that program to Accelerated Clean Energy Buyers Program.
Thank you, Madam Chair.
All right.
Madam Chair.
I see Delegate Williams.
I think this was the bill I was thinking of. And so now it appears that fusion and nuclear energy are not in this bill any longer.
Madam Chair, they are in statute, but they are not, the substitute took those words out of the bill. That's correct.
Okay, that's good. All right, seeing no more questions, are we ready to cast our vote? I'll ask the clerk to open the roll for us. And the clerk shall close the roll. The bill passes 20-2 to report this bill with a substitute.
Next, Madam Chair, was HB 590 from Delegate Hernandez, which creates the Smart Solar Permitting Platform to serve as a tool for contractors to obtain permits for the construction of residential solar energy systems and localities to process applications for such permits. It requires the Department of Energy to establish, launch, and administer an internet-based platform that automates plan review and instantly releases a permit or a permit revision to construct certain residential solar energy systems that comply with any applicable building codes and state laws. The bill requires localities to allow contractors to submit an application to construct a residential solar energy system through that platform or through an alternative automated solar permitting platform by January 1, 2028. The bill requires any locality that chooses to use an alternative automated solar permitting platform to submit an annual report to the department no later than March 1 of each year, and it directs the Department of Energy to establish, launch, and administer the platform by July 1 of 2027. There was a substitute, Madam Chair, which adds the capacity to process applications for streamline eligible residential solar systems and adds preserving the permitting authority of localities on line 51. It also adds that the provisions of the bill shall not affect interconnection and approval processes established by SEC regulation for an electric utility. The subcommittee recommended reporting with a substitute and referring this bill to appropriations by a vote of 8-1, and I so move.
Second. Okay, it's been properly moved and seconded that we report this bill with the substitute and refer to appropriations. Is there anyone on this committee who might have a question? Delegate Runyon.
Madam Chair, thank you, Madam Chair. I would ask of the patron, is this optional, permissive for the localities, or ultimately required? Thank you, Madam Chair.
No, it isn't. Madam Chair, the answer to the delegate's question is that the bill does require localities to allow contractors to submit an application using this method.
Thank you, Madam Chair.
You're welcome. Okay. We have properly moved and seconded this bill, and are we now ready to cast our votes? I will ask the clerk to open the rolls. And the clerk shall close the roll. The measure passes 14-7. The bill will be reported with the substitute and referred to appropriations. Chair Sullivan.
Madam Chair, the next bill was HB 634. From Delegate Kilgore, which the subcommittee recommends incorporating into HB 1393, and I so move.
Okay. It's been moved and seconded that we incorporate this bill into House Bill 1393. Any questions from any member of the committee? All right, this is I don't see any comments. This is a voice vote. All in favor? Aye. Any opposed? The measure passes. House Bill 634 will be incorporated into 1393.
Yes, ma'am.
Thank you, Madam Chair. HB 889 from Delegate Shin. There was a substitute which changed the bill into a Section 1 bill, stating that it's the policy of the Commonwealth to prioritize using existing infrastructure corridors over new corridors to the extent feasible. It It requires DOT to convene a stakeholder work group to develop recommendations about permitting and siting transmission infrastructure and to report by November 1, 2026. The subcommittee recommended reporting that substitute by a vote of 9-0, and I so move.
Okay, properly moved and seconded that we report this bill with the substitute. Any questions from any member of this committee? Seeing that there are none, we'll ask the clerk to open the roll so we can vote. And the clerk shall close the roll. This measure passes 22-0. We will report this bill with the substitute. Chair Sullivan.
Madam Chair, next was HB 1073 from Delegate Rasool, which directs the SEC to promulgate regulations for pipeline leak detection and repair standards for pipeline facilities used in the intrastate transportation of gas that are at a minimum as protective as the standards set forth in the Pipeline Safety and Pipeline Leak Detection and Repair Final Rule issued by the U.S. Pipeline and Hazardous Materials Safety Administration in January of 2025. There was a substitute which directs the SEC to base the standards on federal standards, provide certain exemptions, and the regulations would expire upon the issuance of a federal final rule from the U.S. Pipeline and Hazardous Materials Safety Administration. The subcommittee recommended reporting the substitute by a vote of 8-0, and I so move.
Second. Okay, it's been properly moved and seconded that we report this bill with the substitute. Any questions from any member of the committee? Seeing that there are none, I'll ask the clerk to open the roll so we can cast our votes. And the clerk shall close the roll. The measure passes 22-0. We will report the bill with the substitute. Chair Sullivan.
Thank you, Madam Chair. HB 1099 from Delegate Webert increases from $100 per kilowatt of nameplate capacity from renewable energy sources that are located on brownfields to $200 per kilowatt of nameplate capacity from renewable energy sources that are located on brownfields. The grant amount a project developer can receive from the Virginia Brownfield and Coal Mine Renewable Energy Grant Fund. This bill is a recommendation of the Commission on Electric Utility Regulation. The subcommittee recommended reporting it and referring it to appropriations by a vote of 10-0, and I so move.
Okay, it's been properly moved and seconded that we report this bill and send it to appropriations. Anyone with any questions before we move forward? Seeing none, I'll ask the clerk to open the roll so we can vote. And the clerk shall close the roll. The measure passes 22-0. The bill is reported and sent on to appropriations. Chair Sullivan.
Madam Chair, next is HB 1102 from Delegate Singh, which specifies that for purposes of the Renewable Energy Portfolio Standard Program, it requires Dominion Energy and American Electric Power to annually procure and retire certain percentages of renewable energy certificates from geothermal heating and cooling systems. The bill amends the method by which renewable energy certificates from geothermal heating and cooling systems are calculated and directs the SEC to prepare and deliver a report evaluating the procurement and retirement of RECs from geothermal heating and cooling systems on or before November 1, 2028. The bill also directs the Real Estate Appraiser Board to promulgate regulations requiring the development of a continuing education curriculum and requiring training for all licensees that includes how to properly determine the increase in value of real estate created by reductions in building energy costs associated with solar, geothermal, and solar water heating investments. There was an amendment, or several amendments, Madam Chair, which first restored the original language on lines 411 through 416, and also added that if the utility is exempt from making a deficiency payment because geothermal RECs are not available, The utility must submit a payment for the equivalent amount of RPS-eligible RECs. The subcommittee recommended reporting with amendments by a vote of 9-0, and I so move.
Okay, it's been properly moved and seconded that we report the bill with amendments. Any questions, any comments from any member of this committee? Seeing none, I'll ask the clerk to open the roll so we can cast our votes. And the clerk shall close the roll. The measure passes 21-1. The bill is reported with amendments. Chair Sullivan.
Madam Chair, HB 1127 is next from Delegate Reed, which increases from 1 year to 2 years the maximum length of time the SCC is authorized to approve toll rate increases under the Virginia Highway Corporation Act of 1988. The bill also requires the Commission to issue a final order regarding any application for approval of 1 or 2 years of such toll rate increases to be entered within 9 months or 12 months, respectively, after the date of the filing of such application. Subcommittee recommended reporting by a vote of 9-0, and I so move.
Second.
Properly moved and seconded that we report this bill. Any questions, comments from any member of this committee? Seeing none, I'll ask the clerk to open the roll so we can cast our votes. And the clerk shall close the roll. The measure passes 22-0. The bill is reported. Chair Sullivan.
Sorry for the delay, Madam Chair. HB 1393 is next from Delegate LaVere Bowling, which amends annual funding commitments for the purposes of the annual pilot program for energy assistance and weatherization for low-income, elderly, and disabled individuals conducted by Dominion Energy and Appalachian Power. Under the bill, Appalachian Power is required to continue its pilot program at no less than $1 million and no greater than $1.5 million annually. Dominion is required to continue its pilot program at no less than $156 million and no greater than $204 million for the time period beginning July 1, 2026 and ending July 1, 2038. The bill extends the sunset date of such pilot programs from July 1, 2028 to July 1, 2038. The bill further provides that Dominion Energy may recover costs associated with certain electrical facilities that have been approved by the SCC as of December 1, 2038, notwithstanding any time limitations on such cost recovery in current law. There was a substitute, Madam Chair, which removed provisions from the introduced bill that amended the Commonwealth Clean Energy Policy, and this bill, as we talked about earlier, incorporates HB 634. The subcommittee recommended reporting with that substitute by a vote of 9-0, and I so move.
Okay, properly moved and seconded that we report this bill with the substitute.
Madam Chair.
I see Delegate O'Quinn's name is lit up.
Yes, ma'am. I have a question either for Delegate Sullivan or Delegate LaVere Bowling. Whoever wants to take it.
You can proceed.
So in this bill, the not less than 1 million, not greater than 1.5, and then 156 and 204. Now, sometimes we talk about ratepayer dollars and sometimes we talk about shareholder dollars. Am I reading the bill correctly that this is shareholder dollars and not ratepayer dollars?
Madam Chair, I believe the answer to that question is yes.
Thank you, Madam Chair.
Any other questions? Seeing no other lights lit up, then I'll ask the clerk to open the roll so we can cast our votes. And the clerk shall close the roll. Oh, one person didn't vote. That was me. Okay, the measure passes 22-0. The bill reports with the substitute. Chair Sullivan.
I wasn't going to tell anyone, Madam Chair. HB 1444, Madam Chair, from Delegate Lopez was next. It creates the Virginia Clean Energy Innovation Bank to finance clean energy projects, greenhouse gas emissions reduction projects, and other qualified projects through the strategic deployment of public funds in the form of grants, loans, credit enhancements, and other financing mechanisms. The bank's governed by a 12-member board of directors consisting of 9 non-legislative citizen members and 3 ex officio members with voting privileges, who include the Director of the Department of Energy, the Chief Executive Officer of the EDP, and the State Treasurer or their designees. The bill contains provisions for the appointment of a president and the hiring of staff, the powers and duties of the bank, lending practices, a strategic plan and investment strategy, public outreach requirements, audits, exemptions from taxes, and from personnel and procurement procedures, and reporting requirements. The subcommittee recommended reporting and referring this bill to appropriations by a vote of 6-3, and I so move.
Okay, it's been properly moved and seconded that we report this bill and refer it to appropriations. Any questions from any member of the committee? Seeing no lights on, then I'll ask the clerk to open the roll so we can vote. And the clerk shall close the roll. The measure passes 15-7. Bill passes 15-7, and we will report and refer to appropriations. Chair Sullivan.
Thank you, Madam Chair. The final bill for the committee's consideration is HB 1467 from Delegate Lily Franklin. It requires Appalachian Power to petition the SCC for approval to conduct a pilot program to evaluate methods to optimize demand through various technology applications, including the establishment of virtual power plants by July 1, 2027. The bill requires the pilot program to evaluate electric grid capacity needs and the ability of such virtual power plants to provide grid services, including peak shaving during times of peak electric demand. The subcommittee recommended reporting by a vote of 9-0, and I so move.
Second. Properly moved and seconded that we report this bill as it is. Any questions from any member of this committee? Seeing no questions, I'll ask the clerk to open the roll so we can vote. And the clerk shall close the roll. This measure passes 22-0. This bill will be reported.
Madam Chair, that concludes this report from Subcommittee 3.
Wow, we have finished with our docket for today. I just want to mention that I think we've done a great job. I know the subcommittee chairs are doing a wonderful job, but all of us are doing a fantastic job. Do you notice this time no one came up to ask to add an amendment to the bill? You see what happens when we do everything in subcommittee? We get finished faster. We're going to just be at, I'm going to say at ease for just 2 or 3 minutes. Well, first of all, let me get a motion for us to really move that we adjourn, and subcommittee will pick up right afterwards. Full committee is adjourned.